This week on Just Solutions, the Supreme Court is considering a case that could upend the EPA's ability to protect our water from toxic pollution. This is part of a wave of efforts to undermine environmental regulations playing out in the court. The decision in the case will have far-reaching consequences for the Clean Water Act. Our guest today is Sam Sankar, Senior Vice President for Programmes at Earthjustice. The group has filed an amicus brief to the Supreme Court in the case of Sackett versus the Environmental Protection Agency. Their clients are 18 Native American tribes who are calling for water protections. Sankar says we need judges who recognise the value of our federal environmental laws, the importance of sound science, and the proper role of the judiciary. From Free Speech TV, Just Solutions. Sam, it's great to have you with us. Thank you for being our guest today.
Oh, thank you so much for having me.
So are we overstating it that this particular case being considered by the Supreme Court could really upend the Clean Water Act and environmental regulations around water as we know it?
No, it's not an overstatement. The Supreme Court has been interested in the scope of the Clean Water Act for a long time, and this is certainly a case that I think it's fair to say it took in order to make some statements about that.
Well, let's talk a little bit about the case, Sackett versus the EPA. It's about a specific aspect of the Clean Water Act. So what exactly is at stake here? What is being considered?
Sure. The Clean Water Act, the text of the Clean Water Act says that EPA and other federal agencies are supposed to be protecting the waters of the United States. And that term is very broad. And so the question is, what exactly does it cover? For almost 50 years now, the federal government has taken the position that waters of the United States includes wetlands, both adjacent to waterways and also wetlands that affect waterways, because wetlands, as you know, protect waterways by filtering sediments, dealing with pollution, providing a habitat for fish and insects and aquatic life. And the question in the case is whether or not and what kind of wetlands are subject to the Act's protections.
So I know that back in 2015, the Trump administration, or rather back in 2015, the EPA issued sort of, I don't want to say a decree, you can correct me on the correct language, defining what WOTUS is, Waters of the United States. And that was challenged by the Trump administration. And then Earthjustice stepped in there, also representing Native American tribes. So take us back to 2015. What is that WOTUS declaration?
So we've had a series of WOTUS declarations over the course of many years, ever since the statute was issued. And consistently, every administration, including the Trump administration, has concluded that the definition of waters of the United States, WOTUS, covers wetlands and covers wetlands even when they are separated to some degree by the nearby waters. The Trump administration, back late in its term, issued regulations that offered a fairly narrow description of it, again, including some wetlands, and Earthjustice challenged those regulations in court successfully.
Well, for viewers and listeners who aren't really familiar with what exactly wetlands do, you mentioned their function in terms of filtering, but what exactly are wetlands and their important function in the environment?
Sure. Wetlands are regions of our geography that are characterized by the regular presence of waters. So you can think of things like marshes as being a classic wetland. Wetlands are areas that may not be navigable, like you couldn't necessarily paddle a canoe or pull a boat across them, but they're inextricably intertwined hydrologically, ecologically, and environmentally with associated surface waters. So the main thing you need to understand is that they are deeply intertwined with surface waters. And if you want to protect surface water quality, you can't neglect wetlands protection, because once you neglect wetlands protection, people can dump into and fill wetlands, they can pollute wetlands, and that pollution inevitably makes it downstream because those wetlands are connected to the surface waters.
In regard to this particular case being considered by the Supreme Court, what exactly is at stake here, and who are some of the political and legal players at play? Earthjustice, of course, issued an amicus brief in support of water regulation and water protection. But talk about the Pacific Legal Foundation and some of the other folks that are they're supporting the Sacketts, this couple who are challenging the EPA.
Right. Well, first and foremost, we have the Sacketts themselves. The Sacketts would like to paint themselves as fairly sympathetic, innocent landowners. But what the record shows is that they're actually the owners of excavation companies. They're well aware of the rules and regulations concerning wetlands protections. They bought a lot that EPA and the Army Corps of Engineers had already determined was subject to EPA's wetland regulations. And they knew that they could have sought a permit to develop on the land anyway. That's a very important thing. Nobody was saying that they couldn't do any development. They merely needed to get a permit. Rather than getting that permit, they actually brought in 1,400 cubic yards of gravel with their own company and had their company fill the land in. It was during the middle of that filling operation that neighbors complained, and EPA showed up and said, "Hey, we're not so sure that this is okay." So at that point, the Sacketts presumably needed legal help, and they got the support of the Pacific Legal Foundation. And Pacific Legal Foundation is a legal organization that is funded by, I think it's fair to say, by right-wing and industry interests. They get a lot of donations from corporate entities, and that allows them to represent people like the Sacketts in a campaign, a legal campaign that is relevant to the Sacketts, but of course much more broadly relevant to the industry interests that support organizations like the Pacific Legal Foundation.
And I think that's worth mentioning, the other entities at play here, because this will have broad ramifications. I mean, what's really at stake with the decision on this? It goes well beyond the Sackett's personal case.
Right. The Sacketts own less than an acre, but the reason that they're getting all the support, not just from the Pacific Legal Foundation, but from amicus briefs from dozens of industry groups, is because there's 45 million acres of wetlands at stake. The Sackett's position in this case would cut off protection to those 45 million acres of wetlands and would in addition change the way EPA is able to protect smaller ephemeral streams, that is, streams that run only seasonally in parts of the year. So it's of huge importance. So and that again is why the Sacketts are attracting this much support from right-wing and industry interests.
We'll talk about Earthjustice's role in this. Who are the tribes you're supporting and why are they concerned?
Sure. We're representing a group of 18 Native American tribes in this matter. And the reason why the tribes are concerned is, well, for the same reason that many of us are concerned. First of all, they rely on water quality for their ways of life. We all rely on water, and in many cases, tribes rely especially heavily on the water supplies in their regions for fishing rights, for subsistence, just for drinking water, and for their way of life. And in many cases, tribes don't necessarily have the same legal powers to protect themselves that, say, states do. So they have particular concerns in that regard. And finally, tribes also have treaty rights. In many cases, they were forced onto reservations or forced into treaties. And at the very least, those treaties and reservations were supposed to guarantee them an environment in which they could in which they could live their way of life or continue fishing as they were historically able to. But if you can't protect the wetlands and upstream waters of the places where they live and hunt and fish, it's going to compromise their ability to actually exercise those treaty rights or to live on the lands that they have in the way they're accustomed to.
And this is such an important issue because water around Indigenous rights is absolutely a huge issue that's completely underaddressed. And I know the Navajo Nation are one of the tribes that you're representing. And if you just look at water in terms of the context of the Navajo Nation, 30% of the community of the Navajo Nation don't have access to clean drinking water. I mean, this is not an isolated case. It's not just about wetlands in terms of Navajo Nation and water rights. I mean, talk a little bit about that, about how the Indigenous communities, the tribes themselves, are already battling a huge uphill battle when it comes to water issues.
Sure. A good example is the Fond du Lac tribe that we represent. And 50%, over 50% of their reserved lands are wetlands. So a huge amount of just their home is wetlands that would lose protection if the Sackett's interpretation goes the way that they would like. In addition, these communities are facing threats from upstream mining and upstream industrial development that they are currently able to hold at bay to some degree through legal actions based on the Clean Water Act. Among other things, they can challenge permitting decisions when the Army Corps of Engineers or EPA says you can develop in this sensitive area, the tribes can go in there and argue about whether those permitting decisions were correct. And at the very least, all of those permitting processes give the tribes the opportunity to identify their concerns and make sure that people are aware of the impacts of what would happen on their way of life. So if you remove wetlands protections, you're not only removing the actual protections for these places where the tribes live, but also for the upland and upstream areas that affect them.
This isn't the first case on the docket of the Supreme Court when it comes to environmental deregulation. I mean, earlier in the summer, the Supreme Court ruled around the EPA's ability to regulate emissions and really dealing a blow to the Clean Air Act. Talk a little bit about your concerns about the current makeup of the Supreme Court and its attitude right now to environmental regulation and consequently deregulation.
Sure. I think it's fair to say that there's been a long-term campaign by industry interests to make the court a receptive audience for deregulatory arguments. The current bench that we have on the court was picked in significant ways for hostility to federal regulatory interests, or at least skepticism to federal regulatory power, for their interest in private property rights over public environmental concerns. And this is ground zero for a lot of those deregulatory legal philosophies is the environment, because polluting industries in general don't like to be regulated. They know that when you regulate in the public interest, it may affect their bottom line. And so they are always going to push against those regulations and try to limit them. It is natural. I say this all the time. We shouldn't be surprised when extractive industries and corporations fight against regulations. That is what they do. But we just have to be aware that we need courts and we need our laws to protect people from the natural behavior of corporations.
It does seem that so much that governs our society when it comes to healthcare, women's right to choose, the environment, it's playing out in the Supreme Court. Is that an indication that our laws are working, that they can either be challenged or upheld? Or is this an indication that, you know what, we need more regulations so that we're not constantly having the courts actually be the ones that are deciding so much of what's so important to us right now?
Sure. Well, I think in America, we have a political process that isn't working as well as many of us would like. And that plays out in a couple of different ways. One is that Congress isn't writing a whole lot of new laws of any kinds to really address some of the emerging problems we have, whether it's climate change or racial injustice or anything else. And the second thing is, on the flip side of it, the industry interests that would love Congress to rewrite the laws to be more deregulatory is finding that it just can't get any traction for that kind of legislative change. The public broadly supports environmental protections. So if you can't get Congress to rewrite the laws, and you can't persuade the agencies that the science supports weakening the laws, and the industries haven't been able to do that either, what's your last opportunity? Well, maybe you can get the courts to rewrite the laws. And so that's what I think we're seeing, is that the industry interests that are at play here have engaged in a long-term campaign to make the courts a favorable venue for themselves, and are now asking the courts to do what they have not been able to get politically, which is changes in the laws.
Well, we would love to hear from our viewers. Let us know where you're watching. Let us know your thoughts on this case. Have you been aware of the Supreme Court and the potential implications of a decision when it comes to the protection of wetlands, and then the knock-on effect around the Clean Water Act? Maybe this is playing out in your own community. Maybe you're concerned about this in a very specific way. Join the conversation. Drop us a comment. Let us know your thoughts. You mentioned there, Sam, about these industry interests, and we spoke earlier about that when it comes to this particular case, Sackett versus the EPA. And I've heard it being said, I think probably by Earthjustice, that what we're seeing really right now is a coordinated push by industry polluters. And it's not just at the Supreme Court, as you said, it's when, we look at what's playing out in Congress as well. Expand a little bit more on that, because I think when we hear about cases, say this one at the Supreme Court or other things, we often don't look at the bigger picture and see the coordination when it comes to who's behind this. I mean, did the Sacketts go out and find these organizations to support them? Or are these industry interests out looking for these kind of cases that could upend these federal protections?
Well, I think it may not be that individual, industrial companies are out there looking for them. But what they've done is they've funded a network of activist lawyering groups that are actively looking for these cases and that are identifying cases like or families like the Sacketts as potential vehicles for the claims that they want to make. Because of course the case is less sympathetic if it's Exxon coming in and saying, "Hey, we're trying to fill in a wetland. Why can't we fill in the wetland?" And that's why it's appealing to bring the case on behalf of individual people who are property owners. Now, I think it's telling that the individual people they found are also owners of a large excavation company, people who actually are well aware of, likely well aware of what they're doing. But the industry interests that you're talking about are the ones that that routinely deal with dredging and filling and polluting wetlands. And again, these are industries like the oil and gas industry, the mining industry, and agricultural interests that routinely would like more freedom to pollute, fill in, and degrade wetlands and the nearby water bodies. That is part of their business model, and the less regulation they have to face in doing it, the more profit they make.
What ultimately could the Supreme Court decide in this? Is it like a yes or a no situation? Is there something in between? I mean, what should we be anticipating? Albeit a decision isn't expected until next year, but what could actually come down from the court?
Sure. What's interesting is that the Sacketts and their industry allies have asked the court to write into law a fairly bright line test for what counts as a wetland or a protected water. And that bright line is, look, if you can't, if that wetland isn't directly touching the water and isn't visually indistinguishable from the nearby water, then it can't be protected. And what we saw at argument was a lot of the members of the court, even some of the conservative members, recognize that interpretation doesn't really square with the text of the law that Congress wrote in 1972, with amendments that came out in 1977, and with 7 consecutive presidential administrations' interpretations of that law. So what we're going to find out is whether or not those judges who asked good questions at oral arguments and expressed some skepticism of that very aggressive bright line test, we'll see whether their judicial instincts are what actually lead them to the decision that they make, or whether it's more of a deregulatory agenda and some legal philosophy that ends up driving their decision making. That's what we should be looking for, is do we get a bright line test driven by a legal philosophy, or a more nuanced test that reflects science and the difficulty of drawing bright lines in the real world?
Now, we've spoken about what's at stake specifically in this case, waterways, and these, waters as defined under waters of the US, that kind of decision by the EPA. But are there other waterways at stake here? I mean, is there an even further knock-on effect? Will this embolden other entities to come and challenge other parts of EPA regulation around water protection?
Well, I certainly think that we have a court right now that many observers rightly understand as being very receptive to deregulatory arguments. So I think that no matter what happens in this case, we're going to see a continuing parade of requests to the court to cut back and reinterpret existing environmental laws more narrowly, to reduce the discretion and latitude that our expert agencies have to implement those laws, and to elevate, quote, private property rights over public health and environmental protections.
And I think it's always worth reminding people about what we talk about them in such broad terms. Clean Air Act, Clean Water Act, it's almost this ubiquitous entity that's just there. But if we remember what happened, or what the situation was before these actually went into effect, I mean, what exactly has been the successes? I know it's not a perfect package of regulations, but there have been some very considerable successes when it comes to water. What does the Clean Water Act do?
Sure. Well, before the Clean Water Act was passed in 1972, we had literally rivers catching on fire. We were losing 450,000 acres of wetlands every year. And Congress itself recognized that this was a completely unacceptable situation. Congress had tried to let states take the lead in water regulation, and it had just miserably failed, and Congress acknowledged as much. So what the Clean Water Act does is it sets a goal of zero discharge of pollutants to our nation's waterways. And then it basically says, if you want to pollute the water, in order to get us to that zero pollution goal, you have to get permission before you let any pollutant out into the water. And as part of that permission, which we call a permit, we're going to put in limits on the way that you can pollute, require you to treat what you're doing, or if you want to fill in a wetland, require you potentially to compensate for that damage, either through construction practices or by restoring wetlands elsewhere. So that permitting process, which is the heart of the Clean Water Act, is what allows the agencies to evaluate the actions of industries and modify those actions so as to reduce or eliminate their impact on the environment. That's the heart of the Clean Water Act, these permitting requirements. So when industries are saying we want to get rid of the permitting requirements, they're eliminating the agency's ability to consider activities and regulate them.
This is all happening at a time when we are seeing diminishing water supply. The Colorado River is in crisis. It's over-allocated, has been since the compact was established. But of course, now we're living through the climate crisis as well. And very often we're having these conversations about water quantity and diminishing water supply. But water quality is really at the heart of what we're talking about today, and pollution and protection of these water spaces and waterways from polluters. But what is the intersection? I mean, what is the connection between water quality and water quantity? And why should we be paying attention to all of it at the same time?
Sure, they all go together, and wetlands are actually a perfect example of how and why. Wetlands, wetlands address both water quality and water quantity. So wetlands filter pollutants, control settlements. They do a lot to improve the water quality of nearby waters, but they also act as critical buffers for water flow. So in flood times, your wetlands absorb the water and reduce the flooding of nearby water bodies. And in dry spells, the wetlands let go of that water and maintain flows in our rivers and lakes and streams. So protecting wetlands is critical to protecting both water quality and quantity. What's interesting is that while the Sacketts really did not want to talk about that, many of the justices of the court, including several of the conservative justices, acknowledge the critical role that wetlands play and the difficulty of protecting water bodies without protecting wetlands.
I think when we talk about water issues and wetlands and rivers, it's a perfect example of why federal regulation is so crucial, and not just having regulation at a state level, because of course rivers flow through, they don't recognize state boundaries or governmental boundaries. And so you need to have these broad federal regulations. And when so much of the conversation is, well, we leave it up to states to regulate it, you cannot do it in cases of natural entities, essentially, because as we said, rivers don't know state boundaries.
Yeah, there's a couple of reasons why state regulation isn't an adequate solution. You've named a couple of them already. One of them is there are states downstream from other states. So if you're an upstream state, you can let that pollution go out of your boundaries and not worry about it. And it's really going to affect your neighbors, not you. So your incentives to control the people who are inside of your boundaries are actually lower than they should be. The other thing is there's this concern about a race to the bottom. Oftentimes, we know that states are competing to attract investment from industries, and it's always going to be tempting to say, we'll regulate a little less in order to get you to put that factory or that mine or that pipeline through our state rather than through the neighboring state. So that's a reason why states are always, there's always a temptation to race to the bottom, as they say, and putting a federal floor of regulation in is really critical.
So this is, as we said, before the Supreme Court. They've already heard arguments, but a decision isn't likely to come down before 2023. So is there anything that people who are concerned about this can do right now?
I think the number one thing to do is to educate yourself about the issues and to be aware of them, because first of all, people assume that the Supreme Court doesn't pay any attention to what's going on in the real world. And I do think that that broad movements do matter to the court, and that the court is not actually blind to what's going on in the conversation in the public. Just as importantly, if the Supreme Court tries to limit the reach of the Clean Water Act by reinterpreting some of the longstanding language, there is an opportunity for Congress to take action and to actually reinstate a broader understanding of the Clean Water Act. And that's something that people should be prepared to push for through their legislators and representatives.
And this idea of educating themselves, I think a crucial part of this is that people need to be educated on, a major component of this that we touched on, what's happening with the tribes and water quality, because this is much broader than this particular case. I know Earthjustice has worked very closely with the various different tribes on this. How can people weigh in on this, even outside of this particular case? But water access, the fact that so many different tribes have such limited access to clean running water, let alone the pollution of waterways that's at stake with this. How can people educate themselves on this? Because these are not topics, these are not stories that are often being put out there, certainly into mainstream media.
Sure. Well, we try to put a lot of the stories of our partners on our website and make sure that we communicate those out very well. One of Earthjustice's important roles in partnering with the tribes that we work with is not just to represent them in court, but to elevate their voices and make sure that their stories do get heard. So if you are someone who's interested in these issues, dig a little deeper, go beyond the front page of the big newspapers or the top level Twitter feed that you get, and read some of the stories that Earthjustice and the tribes themselves are putting out there and learn some of these things. And then communicate that to the people you know. There is no substitute for making sure that there are broad movements in support of tribes, tribal water rights, and water quality. Legislators pay attention to that. And finally, vote. You got to vote. Make sure that your elected representatives are aware of where you stand and that you're voting your values.
And just in terms of voting, we talked earlier about the need to have robust federal regulations, that state regulations aren't enough. However, there are a lot of things happening when it comes to environmental regulation and deregulation at a state level too. So albeit federal regulations are important, I think people need to also, I'm sure you would agree, pay attention to what's happening locally at a community level and at a state level too when it comes to environmental regulation.
Absolutely. There's a great deal of progress that can be made at the state level and a great deal of damage that can be done at the state level as well. And I think paying attention to all levels of government is really important for anybody who is active and committed on environmental and justice issues. In addition, I think people need to be aware of the courts. We've talked about the state government, we've talked about federal government, we've talked about voting, but people need to recognize the importance that the courts play in environmental protection. If we have a solid Congress and good laws and good regulations, that will only help us so much if the courts that we're going to bring life to those laws aren't necessarily seeing the value of those broad environmental laws to the general public.
And we've already seen the disposition of the current Supreme Court when it comes to environmental deregulation. Well, Sam, thank you very much for being our guest today on Just Solutions.
You're very welcome. Thank you for having me.
And don't forget, Just Solutions is also available as a podcast. So subscribe to it and never miss an episode. And you can watch past episodes of Just Solutions at our website, freespeech.org. And don't forget, join us next week, same time, same place, for another conversation from Free Speech TV's Just Solutions.